What do the statistics tell us about the odds that the Supreme Court is going to do something really good for the Second Amendment using that Snope versus Brown case dealing with the AR-15 semi-automatic rifle ban out of Maryland? Let's talk about this when we come right back. You're not going to want to miss this one. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, so I haven't talked about the Snope case for a little bit. I'm just letting it play out at the U.S. Supreme Court level. I didn't want to belabor some point and give you no news is news. It's not really my style. But I think we now have to start talking again about Snope because I think we're moving toward, fingers crossed, candles lit. I think we might be moving forward some positive developments in that case. Now, yes, a lot of what I'm about to say here is speculation, but I think we're starting to, fingers crossed, something good may be happening very soon. That's at least what I'm hoping. And why do I say that? It turns out that right now the U.S. Supreme Court has relisted the Snope case and the Ocean State Tactical case 13 times. 13 times. To put that into some perspective, before the U.S. Supreme Court granted cert in the Dobbs case, which was the case that overturned Roe v. Wade, that Dobbs case was relisted by the Supreme Court 12 times before it was granted. So let's just step back and talk about what are we talking about when we're discussing a case being relisted at the U.S. Supreme Court. Well, as you know, the United States Supreme Court has no obligation, as a general matter, to hear a case. They have virtually unlimited discretion to decide what cases they hear and what cases they choose not to hear. The way you ask a Supreme Court to hear a case on the merits is by seeking what's known as cert. You ask the court to take the case by petitioning for cert or filing a petition for cert. The Supreme Court grants about 1% of these cases every term. The term starts in October and ends at the end of June or the start of July of the following year. During that term, there are thousands and thousands of cases where people seek cert. And again, only about 1% of them are granted at all. And even if you start going up the ladder a little bit to people that are kind of paying clients, if you will, kind of well-to-do clients, the people that are not sort of the prisoner petitioners, if you know what I'm saying, you only get to 4% of those kinds of cases are granted cert, at least according to statistics compiled by the excellent source for Supreme Court information, including statistical information, Scotus blog. We'll get to more about them in just one second. So why do you need to know that the Supreme Court only takes cases where they grant cert? They rarely grant cert. Is because the process by which they decide whether or not to take a case goes basically the following way. A party petitions the court for cert. If the Supreme Court's interested in the case, they ask the other side to weigh in on whether or not cert should be granted. The other side will file briefs. The Supreme Court justices will then look at the briefs, and then they will schedule a conference among all the justices to sit down in a room with only the justices in that room, the 9 of them, and they will vote whether or not to hear a case, whether or not to grant cert. It takes 4 justices to vote for a case to be heard by the Supreme Court. If 4 justices vote for cert in a case, that case will be granted cert, and the court will hear it on the merits. Now, you may ask, well, why wouldn't you grant cert if you have 4 votes? And the answer is, strategically, there are justices that are interested in a topic that are not interested in creating bad precedent. So unless they are certain they have 5 or more votes to rule in their favor, let's say, that justice will not vote for cert. In other words, they want to make sure they know who's going to win the case and how that case is going to be decided before they will vote for cert. That's right. That often happens. So even if you have a justice that would like to hear a case, that justice may vote against hearing the case unless he or she can be certain of the ultimate outcome, because they don't want to create what they consider to be bad precedent just to hear a case. Now, with all that said, let's talk about the Snope versus Brown case and the Ocean State tactical case. Between these two cases, the Snope case is far more likely to be granted cert. This is the AR-15 ban case out of Maryland dealing with semi-automatic rifles. This is the cleanest case. It should be right down the middle. You apply the Heller-Catano precedent. You apply the in common use test. You find that semi-automatic rifles are in common use by Americans for lawful purposes. It's not even a debate. Even if you want to consider, are they dangerous? They're not, because they're dangerous. Obviously, each firearm is dangerous by definition as a weapon. But if you look at the statistics, you only have a few hundred people who are killed by homicides every year with all long guns, which again, any death is one too many and is bad. But the reality is, if you try to compare that with the number of people that are killed via murder using handguns, the handgun number is far greater, which again is not a constitutional consideration, but it's a pragmatic consideration for us just to keep in the back of our mind that if the Supreme Court were going to rule that a gun ban was appropriate on some commonly owned firearm, the handgun would have been the more logical way to go, but they found that handguns were protected under the Second Amendment as well they should have found in the Heller case in 2008. And so therefore, it seems very straightforward that the Supreme Court should find that AR-15, semi-automatic rifles, AK-47s, should readily be protected. Now, beyond the Snope case, we also have the Ocean State tactical case out of Rhode Island. I think this is a lot less likely to be granted cert. I think if the Supreme Court wants to do, but the reason why I bring this up is that both the Snope case dealing with the AR-15 ban and the Ocean State tactical case, which deals with a quote-unquote large capacity magazine ban in Rhode Island, that is on a preliminary injunction basis. We've talked about how, as a general matter, they don't like to hear cases on an interlocutory basis. Unless it's an immunity case, which, of course, the Rhode Island case called Ocean State Tactical is not an immunity case. So if I were a betting person, I would say there's much more likely to grant cert in Snope and then put on the shelf the Ocean State Tactical case and then send that back down after a decision in Snope for further consideration by the lower courts. Or, of course, what could happen is you could grant cert to both cases, but I don't think that's going to happen. I think they will grant cert to Snope or neither. But again, that's just my best guess. Now, with that said, let's turn to the statistics here. There's a lot of stuff going back and forth on X. Costas Moras over there at the at the powerful Chuck Michel firm, the Michel Law Group out there, the Michel Law Firm in California that represents the California Rifle and Pistol Association. Costas out there does a great job. If you're not following him on X, you definitely should be doing so. And again, you should also be following me on X if you're not already doing so, at 4 Boxes Diner. A lot of back and forth. And I bring this up because there was a very good colloquy back and forth between Costas on the one hand and Scotus blog's John Elwood. Now, John Elwood is a professor of law at the University of Virginia. He used to work in the Solicitor General's office. He's a partner at Arnold & Porter, a major law firm in the United States. And he writes for Scotus blog something called Relist Watch, where he tracks the statistics, basically, if you will, of what's going on with Supreme Court relisted cases and other things going on with the Supreme Court. And in the context of this back and forth, which I wanted to bring to your attention, he pointed out that he had done a detailed study several years ago about the odds when a case gets relisted. And he found some very interesting things when he assessed what the Supreme Court statistics show in terms of the number of times a case is relisted. And of course, what does it mean for a case to be relisted? Remember how I told you that the Supreme Court will set a conference for all the justices to decide whether or not to grant cert in a case. And they go back and forth. You need 4 justices to vote to hear the case and grant cert. Now, if the court, for some reason, is not able to decide right then and there whether or not to grant cert, they want to keep thinking about it, they will relist the case for reconsideration a week or 2 later. And then if they still can't come to a decision, they will relist it again and again and again. Now, in many instances, if you see a case that's being relisted a handful of times, 3 or 4 times, what often occurs is someone has decided to write a dissenting opinion. Why? Because perhaps at the first conference of the case, there was a decision by the Supreme Court to not hear the case. Hear what I just said? There's a conference in the case with the 9 justices all by themselves in a room, and they vote to not hear a case. But one or more of the Supreme Court justices are like, I disagree with that. We really should have heard this case. So what happens is, after the Supreme Court has decided and voted to not hear a case, before they publicly announce that, they will let the justices that disagree with the decision draft a dissent. So when down the road, several weeks or whenever it is, the Supreme Court publicly announces that they are denying cert in a case because they're not going to hear that case, they will simultaneously publish with that denial of cert announcement, that order that denies cert, they will publish alongside that a written dissent by the one or more Supreme Court justices that are saying, I disagree with the denial of cert. We should have granted cert in this case, and here is why. Now, we saw this actually in the Second Amendment context back, I think, back really at the end of the Trump administration, part 1, if you will. I think it was the summer of 2000 when the Supreme Court denied cert in the Rogers case, which was the May issue permitting case arising from the state of New Jersey, which was really identical to the Bruen case, which arose dealing with that May issue permitting regime out of New York. And the only difference, of course, between Rogers and Bruen was that in the summer of 2020, when the Roberts Court turned down the Rogers case and denied cert in Rogers, Ruth Bader Ginsburg was still on the Supreme Court. Amy Coney Barrett had not joined yet because Ruth Bader Ginsburg passed away later on that year in September, and Amy Coney Barrett became a Supreme Court justice to replace Ruth Bader Ginsburg in October of the year 2020. And then Bruen came about in the year of our Lord 2022 because Justice Barrett replaced RBG and voted in favor of the Second Amendment. So I bring this up because in the Rogers decision, when the Supreme Court denied cert in 2020, there was a powerful dissent written by Clarence Thomas saying, this is ridiculous, this is a clear case, we are disrespecting the Second Amendment, we are treating it like a second-class right. We, the Supreme Court, should grant cert to this Rogers case and for once and for all decide that the right to bear arms means the right to carry guns in public for self-defense. But the Supreme Court denied cert in 2020 over the Clarence Thomas dissent from the denial of cert. Now, the reason why I want you to understand that is we, in the Snope case, are now past a handful of relistings, a handful of multiple conferences. We are now at the point where there have been 13, that's right, the unlucky number 13 relists, which means 13 conferences, if you will, of the Snope case. And still no decision to grant cert, to deny cert, or anything yet. Now, the reason why it's important to understand this has been relisted 13 times is this is a very big number. And it bodes relatively well, statistically speaking, that the Supreme Court is not likely, but could very well do one of two things. Either grant cert and hear the case of Snope, which is what they should do, or grant cert, but then issue what's known as a per curiam decision, which is what, for example, they did in 2016 in the Caetano versus Massachusetts case, where the Massachusetts Supreme Court basically said that stun guns were not protected arms under the Second Amendment, and the Supreme Court, in a per curiam decision of Caetano, basically told the Massachusetts Supreme Court to redo it and get it right. As a side note, just as a historical side note, most Supreme Court watchers and insiders believe that the concurring opinion by Justice Thomas and Justice Alito, that concurrence in Caetano, was actually going to be the majority opinion of the entire Supreme Court in Caetano. And the reason why that concurring opinion by Justice Alito and Justice Thomas did not become the majority opinion was because a few months earlier, Justice Antonin Scalia passed away in Texas, making a 5-4 victory for the Second Amendment, a 4-4 tie, and a very narrow ruling per curiam, kind of to send the Massachusetts Supreme Court back down to redo it, at which point they then got it right. So with that said, this is what Professor John Elwood has to say about the statistics involving relisting and why we may want to have a little bit of hope that we're going to get some good news out of the Supreme Court involving the Snope case. Here's what Professor Elwood has to say, along with a writing partner, Ralph Mayrell, back then in 2022 when they published this article at Scotus blog. While the Supreme Court justices grant only the tiniest percentage of petitions, relisted cases fare far, far better. For the courts of 2016 through 2022 terms, between 31% and 43% of petitions that were relisted at least once, were eventually granted review. And between 66% and 75% of all cases granted cert were relisted at least once. The odds vary a bit from year to year, and grants among relists are recently on an upswing, but the most basic truth remains: the justices mostly grant cases that they have relisted, and the relisted cases are far more likely to be granted. The article in Scotus blog goes on to says the following: the more relists, the more likely to be summarily resolved. Specifically, they write, that brings us to our next point. As the number of relists increases, so does the chance that a relisted case will eventually be resolved through a summary disposition. This is consistent with our findings in past years, while it remains true as a general matter that serial relists are more likely to result in a summary disposition. The numbers are generally down from a high during the 2017 term. So that's very interesting stuff. Now, specifically, according to this article, when it comes to cases that have been relisted more than 5 times, which the Snope case has now been relisted 13 times, which is more than 5. Those cases that have been relisted more than 5 times, 18% of those are granted cert, and they're just heard in the normal course with full-blown argument and whatnot. Of those cases, 19%, so you got 18% granted cert in the normal course, 19% are granted cert, but they're dealt with summarily, like we saw in Caetano, where there was no oral argument, there was just a grant of cert and a per curiam decision. Those are 19% of the cases where there's 5 or more relists. And then, of course, 63% of the cases that have been relisted 5 times or more are simply denied. So it's still statistically very difficult to get a Supreme Court case before the Supreme Court. And again, as we sit here right now, the Snope case has been relisted 13 times. I should note that the Dobbs case, which is the Supreme Court decision that overturned Roe v. Wade, was relisted 12 times before being granted, and the Masterpiece Cake Shop was relisted apparently 14 times before cert was granted. That, of course, is the case dealing with the rights of the baker, as I recall, whether or not he could refuse to bake a cake for gay weddings or something along those lines. I should note, according to the research done by Professor Elwood there at Scotus blog, again, an excellent source if you're interested in sort of the nuts and bolts of Supreme Court litigation generally across the board, not just Second Amendment. Check out Scotus blog, which I think has just been bought by the Dispatch, but again, that's neither here nor there. For your purposes, I think the record for relists before a case was decided is 23. And the name of that case was Ham versus Joseph Clifton Smith. It was a death penalty case as to whether or not the individual had a sufficiently high IQ to be put to death. And after the 23 relist, there was a per curiam decision basically sending the case back down to the U.S. Court of Appeals for the 11th Circuit saying, make some modifications to how you assess whether or not his IQ is above or below 70, because it's below 70, generally speaking, you don't put them to death because they don't know what's going on. If it's above 70, generally speaking, I think you can put them to death. But again, we don't need to talk about death penalty litigation, for the purpose of this video, other than to say in that Ham versus Smith case, that case was relisted 23 times before a per curiam decision came out, granting cert, and then basically given some guidance to the 11th Circuit to reconsider what to do with Mr. Smith before whether or not to put him to death in terms of his IQ. So anyway, I think overall in terms of Snope, we still got our fingers crossed. I'm still cautiously optimistic good things are going to happen. It's been a long time, and I don't see why they keep dragging their feet if they're just going to deny cert. So So every day we're still alive with Snope and Ocean State Tactical, I think, is a good day. Let's hope they grant cert. They really should. And the fact that the Trump administration's Solicitor General John Sauer and Harmeet Dillon over there at Civil Rights submitted a brief to the Supreme Court urging them to start taking more Second Amendment cases, I think is a positive, big time, with the Supreme Court as to what case they take. Involving the Second Amendment, only time will tell. But again, I think the next case should be Snope, in my view. And if they do grant cert, I think it is a no-brainer that we should win that one and win big. But again, the history of the future is yet to be written. All right, folks, so there you have it. Hope you enjoyed today's episode. Make sure you follow me on X at 4boxdiner. Don't forget to subscribe both to YouTube and Rumble. I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.